Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you.
Start. I will first consider the contentions raised regarding the judgment of the Criminal Court. Stop. The Criminal Court rendered its judgment in April 1984. Stop. The disciplinary authority has not taken the Criminal Court's judgment into account while passing the order of dismissal. Stop. It has now to be examined as to how far this circumstance vitiates the order. Stop. The judgment of the criminal court is a decision on merits acquitting the accused workers. Stop. The acquittal is not on any technical grounds. Stop. The disciplinary authority is bound to take into account the judicial pronouncement of the criminal court and give due weight. Stop. It has not done so. Stop. While conceding this position, the learned counsel submitted that all the charges were not subject matter of the criminal prosecution and hence the order of dismissal is not vitiated. Stop. The workmen were prosecuted for charges under sections 147 and 427 IPC. Stop. These charges, in my opinion, covered almost all the incidents mentioned in the charge sheet. Stop. They are alleged violations of standing orders 16 and 17. Stop. The evidence adduced in the criminal court as well as at the domestic inquiry is the same. Stop. No appeal was preferred against the judgment of the criminal court as it has become final. Stop. It is now settled law that it is not open to the management to ignore the criminal court's judgment. Stop. Para. Even otherwise, the tribunal did not rest its decision only on that point. Stop. The entire evidence was considered and findings were given on merits. Stop. It is true that at more than one places the tribunal repeatedly observed that the criminal court's judgment had been ignored. Stop. But the tribunal had gone into the merits of the case and recorded a finding that the dismissal is not justified. Stop. Apart from the criminal court's judgment, the tribunal independently considered the evidence and came to its own conclusions. Stop. Hence, it is not possible to say that the tribunal mainly rested on its decision on the fact that the criminal court's judgment was ignored. Stop. The tribunal found as a matter of fact that there was no strike on 23rd June 1983 and that the mine worked without any obstruction. Stop. Para. It is next submitted that the Industrial Tribunal has no jurisdiction to reappraise the evidence and come to its own conclusions. Stop. Its power is supervisory and only to see whether the domestic inquiry was conducted in a proper manner. Stop. When once it is satisfied that there is no violation of principles of natural justice in conducting the inquiry, the tribunal has no jurisdiction to set aside the dismissal. Stop. The learned counsel, in support of his contention, relied upon some decisions. Stop. Para. In such decisions, it was held that the Industrial Tribunal could not interfere with the findings arrived at domestic inquiry unless the inquiry is vitiated by violation of principles of natural justice. Stop. But this is a decision rendered prior to introduction of Section 11A in the Industrial Disputes Act. Stop. The amendment brought about on 14th December 1971 introducing Section 11A has enlarged the powers of the Industrial Tribunal. Stop. Section 11A says that when an industrial dispute relating to discharge or dismissal of a workman has been referred to a tribunal, the tribunal must be satisfied that the order of discharge or dismissal is justified, and if it is not so satisfied, it can set aside the order of discharge or dismissal and direct reinstatement or give such other relief, including the award of any lesser punishment as the circumstance of the case may require. Stop. Para. After review of all the earlier cases, the Supreme Court has summarized the principles flowing out of the decisions. Stop. It was observed that when no inquiry has been held by an employer or when the inquiry held has been found to be defective, the employer has a right to adduce evidence before the tribunal justifying his action. Stop.